Hi, everyone, and welcome back to Norton Rose Fulbright's Texas Business Court Insider, where we're tracking developments in the Texas Business Court and beyond. Don't forget to hit like and subscribe.
Today, we're going to discuss how to get into Texas Business Court, including agreements that can confer jurisdiction on the business court. There are two broad types of cases that the business court has jurisdiction to hear. One is corporate governance disputes, and the other is commercial disputes. Rafe, can you tell us about the first category of cases, corporate governance cases? What types of disputes count in that category?
Sure. So for a corporate governance dispute, there's no special agreement necessary to get into Texas Business Court. All you need is a dispute about an LLC agreement or a partnership agreement or some other internal affair dispute. The dispute doesn't have to involve a Texas legal entity. So internal affair dispute about a Delaware entity or a Nevada entity. The Texas Business Court has jurisdiction to hear disputes about those entities. Certainly, parties who are drafting an LLC agreement or a partnership agreement are free to put a forum selection provision in that agreement, mandating suits be brought in the Texas Business Court, but that's not necessary. And in the absence of any such agreement, the Texas Business Court has jurisdiction if the other requirements are satisfied. That means for privately held entities, an internal affair controversy exists with the amount in controversy of $5 million or more. And then for publicly traded entities, there is no amount in controversy requirement. And so the Texas Business Court has broad jurisdiction for internal affair disputes, regardless of where the entity is formed. Now, Rachel, I know that's a little bit different than commercial transactions and commercial disputes. Tell us how to get into business court in commercial disputes.
Sure. So there are several different ways, but let me focus on the ones where you can get jurisdiction by agreement. Now, let me caveat that by saying there are exceptions to the requirements I'm going to give. Some relate to whether the case involves banks, credit unions, savings and loan institutions, legal malpractice claims, personal injury claims, insurance. So lots of exceptions. So check out the statute for those. That's Texas Government Code Section 25A.004. But generally speaking, if you have a dispute that arises from a contract or a commercial transaction, and the dispute has an amount in controversy exceeding $10 million, and the parties agreed in the contract at issue or in a subsequent agreement that the business court could have jurisdiction of the matter, that will actually confer subject matter jurisdiction on the business court. And this is something that's pretty unusual under Texas law. Typically, subject matter jurisdiction cannot arise by agreement, but this is a situation where the statute actually gives the parties some right to determine whether the court can hear the case. Now, Rafe, we've been focusing on subject matter jurisdiction, but I know that's not really the only consideration in determining whether a court or whether a dispute can be heard in the business court. Can you issue spot this for us? What are the other elements that our viewers need to be thinking about when determining whether a case can be heard by the business court?
Sure, Rachel. So you're right. You've talked about subject matter jurisdiction. Certainly when people think about agreements to litigate in a particular forum, they think of forum selection clauses or venue provisions. The type of agreement necessary to get into business court is really kind of a special species because it can hit a lot of different components. You've mentioned subject matter jurisdiction, so you can have an agreement on subject matter jurisdiction. You can also agree around personal jurisdiction issues. And then obviously an agreement to litigate in the Texas Business Court is a species of forum selection agreement. You also need venue. You need to be in a county where an operating division of the Texas Business Court exists. And then the other thing that's especially interesting about the statute that you mentioned, Rachel, is you can have an agreement to proceed in the business court in a commercial dispute that doesn't involve a contract at all. So Rachel, I know you and I have talked about DTPA cases. We've talked about fraud cases where maybe there's some commercial related conduct, but there's not an agreement. In those instances, the statute anticipates that parties can enter into this subsequent agreement that you mentioned, where they can agree to proceed in the business court in the absence of any other contract agreement. And in that sense, a business court agreement is almost akin to an arbitration provision, where the parties are agreeing how they're going to go litigate this claim between the two of them. So parties that are drafting a business court provision on a forward-looking basis, can think about all of these different components as they're drafting. Obviously, that's forward-looking, Rachel. What about for existing agreements? Is there anything people should look out for when looking at a dispute for an agreement that's already been drafted?
Yeah, keep in mind the statute that created the business court was not passed in the legislature until 2023. So a lot of the cases about contract disputes that are being litigated right now focus on contract provisions that predated this legislation. So parties need to consider whether their existing agreements are broad enough to get them into Texas business court, or if they might exclude the Texas business court as a court of proper jurisdiction. So one example, the business court is hearing a case brought by a company called C10. And in that case, C10 is a minority member bringing a derivative action against the managers of an LLC. And these managers were appointed by the majority member. The managers removed the case to business court, and then C10 sought to remand the case to district court. C10 was relying on the LLC's company agreement, which contained a provision saying that the members submitted to the jurisdiction of the district court in Travis County or the federal court in the Western District of Texas. So C10 argued that the case should be remanded to district court because the provision did not specifically name the business court, and it said that these other two courts had exclusive jurisdiction. So in that case, though, the business court determined that this venue provision did not apply. And that's because the managers were not members of the LLC and they were not signatories to the company agreement. So they weren't bound to that forum selection clause. So the court didn't actually have to determine whether the language of that forum provision would have required remand. It avoided the issue. So when looking at existing agreements, you have to think about, is the business court covered by any kind of forum selection clause? And are the parties covered by that forum selection clause? Now, Rafe, I know there are other possible issues that can arise in the context of venue and the business courts. Can you tell us about some?
Sure. I know we've talked a little bit today and certainly in past videos about the fact that only 5 of the 11 possible divisions of the business court are currently operating. So if you have a venue provision like in C1031 that says the suit has to be brought in Travis County, there's a division of the Texas Business Court governing Travis County. There's a division of the Texas Business Court in Houston, San Antonio, Dallas, Fort Worth. But what if you've got a venue provision saying your suit has to be brought in Midland or Amarillo? There's no business court division currently operating for those counties. And so a party who may want, for a case filed in Midland, a party who may want to remove that case to business court may have nowhere to remove it to, while a party to a case filed in Harris County could remove it to the 11th district of the business court. And so in looking at a venue provision or a venue clause, you have to analyze, is there a business court division operating where I can get this case into? That's contractual venue. There are, a lot of other venue statutes under Texas law and mandatory venue principles, Rachel. Have you seen issues arising out of other mandatory venue principles in the business court so far?
Yes, I have. There's a case, it's the Targa v. Franklin Mountain Energy case that addresses a mandatory venue principle. And in this case, the mandatory venue principle at issue was the principle that Texas courts cannot adjudicate title to real property interests that exist outside of Texas. So in this case, FME, Franklin Mountain Energy, had property in New Mexico, and that property had gas. The gas in the ground was real property, but once produced, that became personal property. And FME conveyed interests in both the produced and unproduced gas to Targa. Then there was a dispute in which Targa claimed that FME failed to deliver some of the produced gas. And so Targa brought the lawsuit in Texas business court. Now, FME claimed that Targa actually could not accept all of the gas, and that because of that, FME said it was entitled to obtain a release of Targa's interest in the gas, including gas that was unproduced. So Targa characterized this dispute as one about personal property. FME characterized the dispute as one about real property. And the business court had to determine whether this mandatory venue principle applied to require it to have the case heard in New Mexico. So the court determined that this was actually a personal property issue because the question was really about whether the produced gas had been properly delivered or accepted or not, and any effects on the real property in New Mexico was really just collateral to and incidental to any future judgment that the court might make. So the business court determined this mandatory venue principle related to real property did not apply in the dispute between Targa and FME. But had it determined that the mandatory venue principle did apply, the court may have been confronted with the issue of what happens when a mandatory venue principle and the Texas Business Court statute butt heads. And that was an issue that the court did not have to determine. So that is something we'll be keeping an eye out for in the future to see if the court speaks to that issue.
Yeah, Rachel, I mean, you used the phrase issue spotting earlier, and I think that's the phrase of the day. Certainly, the business court, as we've talked about, has already spotted some issues. Litigants in the business court have spotted some issues. Some of those issues remain outstanding. Norton Rose Fulbright's Texas Business Court Insider, we're going to continue to monitor those cases and further developments in the business court as those questions get fleshed out in the coming weeks and months and years.
To our listeners and our viewers, thank you for tuning in to this episode of the Texas Business Court Insider, tracking developments in the Texas Business Court and beyond. Please subscribe to our channel and stay tuned for the next episodes. You can also visit us at Norton Rose Fulbright's Texas Business Court Insider Hub, which is on our website.